Hello, everyone. This is Samantha Wolfe from the Law Offices of Samantha Wolfe, and I'm here in our conference room today surrounded by these lovely pictures. Thought it would be better to have a different background. So this is our conference room, and this afternoon I just wanted to talk briefly, about healthcare power of attorneys and living wills. So in our office, we actually separate them. We draft them as two separate documents. Typically, when I see them, or sometimes when people come in, they will be one document and they will be called the Advanced Healthcare Directive. We actually prefer them to be two separate documents, and the reason is because the healthcare power of attorney is only effective if you can't express your wishes. The living will is if you can't express your wishes and you have a terminal diagnosis. So both of those things have to be happening in order for the living will to be effective. So we actually like them to be two separate documents rather than one, even though if you put both of them together, that would comprise the Advanced Healthcare Directive. So in the healthcare power of attorney, what we always recommend that our clients have in there is that access to medical information is probably the most important. So we actually put the federal HIPAA release regulation in there, allowing your agent the ability to access your medical and hospital records and any information regarding your physical and mental health. And then it allows them to consent to any treatment that they think that you would want under those circumstances. The living will would be if you can't express your wishes and you have a terminal diagnosis and there's no realistic hope of recovery. So that would be more end-of-life decisions. And usually when we meet with clients, they come in. If they have a previous document, it's more of a check the box, and it'll have sentence about what they do or do not want, and they check the box next to it. And the one that always is included is it says, I do or do not want artificial nutrition and or hydration. And in our office, we actually separate them. So we feel like artificial nutrition and hydration are two separate things. So sometimes somebody may be dehydrated or experiencing pain and they would want to be kept comfortable. And so the doctor is saying that in order to deliver those pain relieving drugs, hydration also has to be administered. And so most clients would say, well, I would want to be kept comfortable. So we actually have something in our document that says that in the situation where you have a terminal diagnosis with no realistic hope of recovery, that you're okay with pain relieving drugs being administered, but you don't want any life prolonging procedures. And that would be anything from surgery, radiation, chemotherapy, CPR, a breathing machine, dialysis. And then we include antibiotics and a feeding tube in that. So again, that's only though if you can't express your wishes and you have a terminal diagnosis. Your agent would be the person who makes that decision. We also include in our healthcare power of attorney a paragraph dealing with dementia or Alzheimer's because that's not a terminal diagnosis. So we include something in there that says if you get that diagnosis and you progress to the point where you lose the ability to swallow, you would not want a feeding tube put in, and you would want those other end-of-life decisions to be applicable at that point. So no end-of-life decisions would come into play there. So we include that in our living will. And again, we also include the same HIPAA release in both the living will and the healthcare power of attorney. The healthcare power of attorney does also typically address whether or not you can be admitted or discharged from any type of facility, including a nursing home and support care that you would need. So we include that as well in the healthcare power of attorney. So again, both of those together make up the Advanced Healthcare Directive, but we separate them into two separate documents. We have the healthcare power of attorney, which is if you can't express your wishes, and the living will, which is you can't express your wishes and you have a terminal diagnosis. So I hope this quick summary helps you understand healthcare power of attorney